Welcome everyone to today's Supreme Court term program. We are pleased to welcome our in-person audience and those attending by webinar. I've been presenting this seminar, I think, for about 12 years, and this is the second time I've had to do it by Zoom. The first time because the world had COVID, and this time because I have COVID. So I'm broadcasting from the deluxe broadcasting booth, also known as my study. Any resemblance I may have to the Wizard of Oz is purely coincidental, as they say. Before I introduce our panel, let me go over some housekeeping matters. First, Dorsey will apply for CLE in the jurisdictions listed on the invitation. Unfortunately, we have a lot of ground to cover today, so if you have a question, you can put it in the chat. We probably won't be able to get back to you today, or at least during the seminar, but we will get back to you, or you can contact your trusted Dorsey contact for that information too. After today's program, we'll send out a survey, and we'd appreciate your feedback. For the in-person attendees, the materials and sign-up form are on the tables. Please be sure to sign in. For the webinar attendees, the materials and attendance form are available for download from the reminder email sent from events@dorsey.com. And don't forget to return your completed attendance form to that same email site. We'll announce a verification code for webinar attendees only for states that require a code, and we'll put the links into the chat to download both in the verification mode. So with that, let me just introduce our speakers. Ian Blodger is a partner. I should introduce myself. I'm Steve Wells, chair of the Appellate Practice Group here at Dorsey for many years. Ian Blodger is a partner in our Appellate Practice Group. Brock Huebner and Jessica Leano are both associates in our Appellate Practice Group, all very experienced appellate practitioners. Let me also thank Daniel Wasim, who is a stellar colleague, associate here at Dorsey, who helped us put together the materials and did some research for us. So with that, let's launch our program. I want to say a few things before we start getting into the statistics, which is how we kick off all these seminars. Obviously, this term was another term of blockbuster decisions affecting the power of the president, Congress, the courts, in addressing important issues of the Second Amendment and various aspects of criminal law, among many other important subjects. Again, this term, stare decisis, took another hit in the form of the Loberbright case. The court directly overruled a prior controlling decision, the Chevron decision that was decided 40 years ago. I will just observe that there is a solid conservative majority on major issues of court doctrine and political importance. But what I would observe is that, as we'll talk about a little today, even the conservative majority has departed significantly from the textualist and originalist legal framework that they've employed over past terms to decide many cases really on policy issues, and we'll go over a couple of those. I would also observe that it's not a conservative monolith. There were, of course, many. We'll talk about this a little later. There were many decisions that were decided unanimously, and there were also decisions in which members of the conservative majority joined the liberals, or vice versa, where members of the liberal minority join the conservative minority. Some things we won't be talking about today: ethics, flag hanging upside down or otherwise, reforms. All those things are very important aspects of what's going on with the court right now, but that's not what this seminar is devoted to. One thing I will point out before we launch into some of the statistics here is that the level of leaking from the Supreme Court has been accelerating at a breakneck pace. This year, everybody, I think, probably remembers the leaks that occurred in the Dobbs case. This year, there were really three significant leaks. One decision that was apparently mistakenly put on the court's website before it was actually officially supposed to be issued. There was an extensive New York Times article not long ago, about 3 weeks ago, that talked about a lot of the internal decisions and discussions that went into Trump versus United States, a case that we'll be talking about to decide the limits of presidential immunity. And then last winter, there was also a significant New York Times issue that talked about internal decision-making regarding the Dobbs decision. These leaks aren't illegal. There's no law against them. They're obviously contrary to court policy. But just a look at how quickly these leaks are piling up would suggest that something is going on inside the court in terms of, I don't know if you'd call it transparency, but a willingness by court employees or perhaps even the justices themselves, we don't really know, to disclose some of the inner workings of the court. So with that, let's turn to statistics.
Great. Thank you, Steve. So before we dig into the discussion of the specific cases, I'll just give a high-level overview of the term in review. So as an initial note, the lineup of justices this term is the same as it was last term, with Justice Jackson as the most recent appointee. A long-running trend on the court is just its declining overall caseload. So if you compare in the 1970s, when they were taking almost 200 cases, this year they only scheduled 61 for argument. And this is in the face of a continued high level of cert petitions every year of 7,000 to 8,000. And so it's just increasingly difficult to get your issue before the highest court in the land. But despite the declining caseload, the pace at which the court issues its decisions, if anything, has gotten slower. Whereas this year, as with the past couple of years, there's just a flurry of decisions that are announced in the last couple weeks of June, and this year, even into July, which of course makes for a lot of news and a busy time for the four of us to write our summaries. So if you compare this year to last year, the rate of unanimous decisions is largely the same, about 45% of overall cases. But if you compare and look at just the cases that were split 6-3, or specifically 6-3 along ideological lines with the Republican appointees on one side and Democratic appointees on the other, you can see a marked increase this past term. Given the low number of cases, it's hard to tell if this is just statistical noise or a sign of things to come, but definitely a trend to be aware of. So another feature of the declining caseload is that the oral arguments for individual cases often extend well past the hour that was traditionally appointed, some lasting 2 hours or more. And that makes for a lot of opportunities for the justices to express their own views and opinions, interspersed with questions for counsel. And the two justices that made the most of the lengthened oral argument time were Justice Jackson and Justice Gorsuch. And this is the second year in a row that Justice Jackson has been the most active justice on the bench. Justice Kagan was a close third behind Justice Gorsuch. At the other end of the spectrum, probably does not come as a surprise that Justice Thomas was by far the least talkative. But he is now asking questions during oral argument, which he did not for his first couple decades on the court. This was another trend that held steady from last year. These three sets of justices were the same three that were most likely to agree last term as this term. So as you can see, each of these three sets, it's very unlikely that you're going to get a voting breakdown in which Justice Kagan and Justice Sotomayor are on opposite sides, and the same with Chief Justice Roberts and Kavanaugh, and Justices Sotomayor and Jackson. On the other side, even for the justices that most people would view as on opposite ideological or jurisprudential sides, they're still agreeing in 50% of the cases, which again, going back to the number of unanimous decisions, There are not that many non-unanimous decisions in which these are agreeing, but still 50% where you can get Justice Thomas and either Sotomayor and Kagan on the same side. Just a couple more. Chief Justice Roberts, perhaps unsurprisingly, is the most often in the majority, as befitting his role as chief. And the two justices who authored, so not just joined, but actually wrote separately in dissent this past year were Justices Sotomayor and Justice Jackson. So Steve touched on a few of these in his opening remarks, but again, the high-level takeaways is just the continued decline in merits decisions with a stable rate of unanimity, looking at all the cases across the board. But when you dig into specific cases, especially the highest profile ones, you see the trend of the ideological fracturing and a clear conservative majority. That being said, where practitioners are most likely to peel off justices, it is most often from the Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett grouping, where commentators often look to them as the potential swing justices in any given case. So with that, we're going to dig into some of the specific cases from this past term. So we'll go to Steve's mute.
I think I'd get it by now. The two cases we're going to tackle first are present the same question, Loper Bright and Relentless. And the question presented was really whether Chevron USA versus Natural Resources Defense Council, a case decided 40 years ago, should be overruled or clarified. The fact that they would take this case and that the court would come out as it did was no surprise to anyone, because the conservative majority has been signaling in concurrences, decisions, and even dissents over the years that they thought that Chevron was overdue for reversal. And that, in fact, is what happened here. In each of the cases that came up, both Relentless and Loper Bright, the question was brought to the fore because petitioners had challenged the government's interpretation of a federal statute that relied on, where the interpretation was the administrative agency's decision, relying on Chevron. The holding in this case was that the Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency is acted within its statutory authority. And courts may not defer, as Chevron required them to do, to an agency interpretation of the law simply because a statute is ambiguous or unclear. The court broke down really here pretty much along ideological lines. In the majority was Roberts, Thomas, Alito, Gorsuch, Kavanaugh. The only exception to that, or I'm sorry, Justice Barrett, there were some interesting concurrences and then a dissent by the three liberal justices. So, as we all probably remember from following these cases over the year, Chevron held that if a statute is unclear or ambiguous, then courts must defer to a reasonable agency interpretation of the statute, even if the court would choose a different meaning using its independent judgment. And that was the decision that was emphatically overruled by the majority here. And the court gave essentially three broad reasons for that. The first is Marbury versus Madison. As we all recall, probably from law school, Marbury versus Madison said it is the duty of the courts to say what the law is. And the court majority in this decision opens with that quote and relies on it very heavily. The court also held that the Chevron was contrary to the Administrative Procedure Act. In Section 706, the majority points out, the Administrative Procedure Act says that it's the reviewing court not the agency whose action it reviews, that is to decide all relevant questions of law and interpret statutory provisions, again, Section 706. And a lot of the decision is devoted to enforcing those two broad principles. One constitutional in the sense of doctrine arising out of Marbury, and the other a statutory construction issue arising out of the Administrative Procedure Act. The court obviously is overruling a decision that's been in place for 40 years. So it seems to be a hallmark of decisions which are varying from stare decisis to talk about the problems that are occurring as a result of the earlier decision. And here the court identifies a number, and I have to say from a observer standpoint, these are much harder to justify. One reason was the court says, well, the agencies can sometimes change their interpretations. And it identifies a couple of instances in which that's occurred. And certainly that's true. Agencies have changed their interpretation of a federal statute. But it doesn't contrast that with its remedy, which is that individual judges will now, following Loper-Bright, be giving their own interpretations, likely leading to multiple interpretations and multiple changes of interpretations of federal statute. The court also notes that the courts have been chipping away at Chevron over the years, and it's unclear to me why this is a ground for departing from stare decisis, since, as the court grudgingly admits, Chevron is pretty much limited at this point only to cases that involve agency rulemaking. So it's been limited very much. But the court says, well, it's running into other doctrines and interfering with the application of those doctrines. But those doctrines are mostly recently created doctrines by this Supreme Court, such as the major questions doctrine that it basically created a couple of terms ago. It also said that Chevron is hard to apply because there are different views of judges about when a statute is ambiguous. That, of course, is true with every court attempting to determine whether a statute, a contract is ambiguous or not. So those were its decisions. I would say there's also sort of a policy aspect to this too, in addition to the explicit grounds, and the court does say this at the end. It's that agencies don't have any special expertise, according to the majority, in statutory interpretation. Courts have that expertise. And so it should be the courts, for all the reasons that they've stated, that do the interpreting, not the agency. The court's clear it's not to say that agency interpretations shouldn't be considered, but they're not controlling anymore. A couple of interesting concurrences. Thomas concurs, joins in the majority, obviously, but also concurs to say that that Chevron causes an impermissible deviation from the constitutional authority of Congress, in the sense that it gives essentially legislative authority to administrative agencies. And that's something that Justice Thomas has mentioned before. Commenters have suggested that that could lead to a sweeping change if the court adopted this in the way that Congress is required to legislate, and legislate much more specifically than it does now. Justice Gorsuch issues a concurrence in which he talks about stare decisis. And again, an interesting concurrence, in the sense that he's very clear that if a sitting justice believes that previous justices have impermissibly departed from the Constitution, or have issued a decision in which the current justice thinks that there's been a violation of the Constitution, then stare decisis simply doesn't apply. I was reminded of this, of the quote from Justice John Paul Stevens many years ago, and I think it was the Atkins decision, talking about the Eighth Amendment, in which he said the justices were required to bring their own judgment to bear. A statement that let out or that loosed howls of outrage from conservatives. But I would say that what Justice Gorsuch is saying right now is that individual justices are allowed to bring their judgment to bear about whether previous decisions are in compliance with the Constitution, and if they decide that it isn't, then stare decisis should fall. The dissent in this case essentially says that Congress, in many cases, deliberately leaves ambiguity in statutes for expertise of agencies to fill in. And this involves, as we all know, things having to do with environmental protection and health and welfare and innumerable other areas, and that should be interpreted essentially as a delegation to Congress, or I'm sorry, to the administrative agency to interpret the statute. It also obviously points to the problem with the impact on stare decisis. So I think the takeaway here is there are obviously direct effects of overturning Chevron that will take a few years to really detect. Individual judges all over the country now are going to be deciding statutory interpretation cases involving technical issues that administrative agencies were handling. And only a few of those will percolate up to the Supreme Court. So it's likely, I think, that there are many different interpretations of federal statutes that could cause confusion. Next slide.
All right, thanks, Steve. We'll continue our discussion of the administrative state. And one of the first cases we've seen, or one of the cases involving the administrative state and the effects of Chevron, is SEC versus Jarkizi. And the question presented in this case was whether the 7th Amendment entitles a defendant to a jury trial when the SEC, Securities and Exchange Commission, seeks penalties against the defendant for securities fraud. And the holding in this case was a 6-3 decision authored by Chief Justice Roberts. And the court held that the SEC's imposition of civil penalties in an administrative proceeding without a jury did violate the 7th Amendment. And we had a concurrence from Justice Gorsuch, joined by Justice Thomas, and then a dissent authored by Justice Sotomayor, joined by the liberal bloc of Justice Kagan and Justice Jackson. So to briefly go through the background of the case, the SEC investigated George Jarkizi Jr., who was a hedge fund founder and investment advisor, for making allegedly misleading statements to investors. And the SEC brought an in-house administrative action charging Jarkizi and his investment firm with violating various federal anti-fraud provisions and sought civil penalties from Jarkizi. Now, Congress created the SEC to enforce federal securities law and permits the SEC to bring enforcement actions in one of two forums. The first forum would be an in-house administrative proceeding within the SEC. And if the SEC adjudicates a matter in-house, a member of the commission or an administrative law judge may serve as the adjudicator and the fact finder, and there's no jury trial involved. The second forum is for the SEC to file a lawsuit in federal court and have the case before an Article III jurisdiction court. Now, as to the civil penalties component, the Dodd-Frank Act, which was passed in 2010 as a result of the financial crisis, gives the SEC the ability to seek civil penalties specifically in federal court or to impose them following an administrative proceeding. And we've seen that civil penalties have been among the SEC's strongest enforcement tools and one of the strongest tools to maintain and uphold federal securities law. So as to Jarkizi, the SEC chose to bring the enforcement action in its own in-house administrative proceedings. And an ALJ found Jarkizi did violate anti-fraud provisions, and Jarkizi sought review from the commission, which affirmed the findings of fraud and imposed a $300,000 civil penalty. Jarkizi sought review from the Fifth Circuit, challenging the penalties and arguing that the SEC's enforcement regime of doing this all in-house was unconstitutional. And the Fifth Circuit agreed with Jarkizi. It affirmed the fraud findings, and it held that imposing civil penalties in an SEC in-house enforcement action was inconsistent with the 7th Amendment right to a jury trial. Now, the majority opinion that was written by Chief Justice Roberts affirmed the Fifth Circuit, and it focused on the Seventh Amendment argument. And it found that the Seventh Amendment right to a jury trial applied to the SEC's enforcement action against Jarkizi for several reasons. The first looked at the types of claims that were being brought. And the claims against Jarkizi, in the majority's view, were claims for violating federal anti-fraud provisions. And these were similar to common law fraud claims. And common law claims must be heard by a jury. And also looking at the civil penalties that were enforced or imposed, civil penalties are the equivalent of money damages. And money damages are the prototypical remedy in common law and the type of penalties that are afforded or imposed by a federal court. And so the court, finding that the case did implicate the Seventh Amendment, then considered an exception to jurisdiction, which is called the public rights doctrine. And under the public rights doctrine, Congress may assign certain matters to agencies for adjudication, even though the proceedings there would not include a jury. On the other hand, matters that concern private rights must be tried with a jury. But the majority found that the public rights exception didn't apply because through the anti-fraud provisions, Congress made claims that were similar to common law claims and allowed for a remedy, civil penalties that are the type that are typically available only in federal courts. So this action against Jarkizi was a common lawsuit in all but name, and that meant that this suit should have been adjudicated in an Article III court, and the Seventh Amendment did apply. Now, the Fifth Circuit didn't address whether the SEC structure violated any other constitutional provision, like the non-delegation doctrine or separation of powers. In the Supreme Court, majority took the same approach. They focused solely on the Seventh Amendment issue. And we have an interesting concurrence from Justice Gorsuch, who was joined by Justice Thomas. Justice Gorsuch agreed with the holding, but found that there were other bases for reaching the same conclusion that a jury trial was required. For Justice Gorsuch, he saw Article III and the Due Process Clause as requiring the same result. We had a fairly strong dissent from Justice Sotomayor, joined by Justices Kagan and Jackson. And Justice Sotomayor took a different view of the historical administrative state. And she found that throughout our nation's history, Congress has authorized agencies to adjudicate disputes, including for violations of federal statutes, and to award civil penalties to the government, representing the government as a sovereign. And Justice Sotomayor noted that Congress has enacted more than 200 statutes that authorize civil or agencies to impose civil penalties for statutory violations. And in her words, Justice Sotomayor found that the majority's decision would unleash chaos after all these years. And she saw a fundamental problem also of a separation of powers issue. And from this decision, she viewed the legislative as being able to, entrust certain matters to the judiciary and bypass the executive. So there's a few takeaways from Jarkizi. First, we may see a decrease in SEC's enforcement actions. There could be a decrease in administrative proceedings and an increase in federal court cases, but given the cost of litigating in federal court, we're likely to see the other results. Before the court released its opinion in Jarkizi, there was already a lower number of SEC enforcement proceedings in-house. As of 2 years ago, before the opinion, there were only 7 pending in-house administrative actions. So this indicates that the SEC may be more selective in who it chooses to bring these actions against. And, we just may see a limited amount of cases brought in-house and in federal courts. And on a broader scale, Jarkizi also raises the question of whether federal agencies will be able to use in-house proceedings to enforce civil penalties at all. There's been at least 3 lawsuits that have been filed against the Department of Labor, making similar arguments as to its ability to enforce civil penalties. And we could see practically that the loss of civil penalties could have a financial impact on the various federal agencies. And there are certain agencies that can only bring enforcement actions in in-house proceedings. So following Jarkizi, it's an open question of whether they'll be able to enforce penalties at all if they can't take these actions to federal court like the SEC can. So continuing on our discussion of the administrative state is another case, Consumer Financial Protection Bureau, CFPB versus Community Financial Services Associations of America. And in the past few terms, we've seen various challenges to aspects of the CFPB, constitutionality, and in this term we had yet another one. And the question presented in this case was whether the CFPB's funding mechanism applies or complies with the appropriations clause. Here we have a 7-2 decision that was authored by Justice Thomas, and the court held that the CFPB's funding mechanism does comply with the appropriations clause. Justice Kagan joined Justice Thomas's opinion, but wrote separately, and was joined by Justices Sotomayor, Kavanaugh, and Barrett. Justice Jackson wrote a short concurrence, and we have a dissent from Justice Alito, joined by Justice Gorsuch. So Dodd-Frank, as you know, applied to the last case, is also was enacted in response to the financial crisis. And by enacting Dodd-Frank, Congress created the CFPB, which is a bureau that enforces consumer financial protection laws. And unlike other federal agencies, the CFPB has a unique funding mechanism. As to other federal agencies, Congress supplies them with funds only on an annual basis, which means these agencies must request appropriations or money from the federal government each year. This is called an annual appropriations process, but the CFPB has a unique funding mechanism, and the CFPB's funding is allocated from the federal treasury's budget rather than through the congressional appropriations process. So in other words, the CFPB has a standing source of funding outside of the annual process that other agencies must follow. And the CFPB is allowed to request, quote, the amount determined by its director to be reasonably necessary to carry out its duties from the Federal Reserve's earnings. This amount is only subject to a statutory cap, and the CFPB is allowed to retain and invest funds from year to year. On this action, trade associations representing payday lenders and credit businesses challenged the 2017 regulation from the CFPB, which focused on high-interest consumer loans. And as part of that action, the associations argued that the CFPB's funding mechanism violated the appropriations clause by giving the Bureau, the CFPB, a self-actualizing perpetual funding mechanism. And under the Constitution's appropriations clause, there was a violation because no money can be paid out of the Treasury unless appropriated by an act of Congress. Practically, this means that Congress has control over public funds, but has to exercise it in a certain manner. Now, the Supreme Court's decision was 7-2 in favor of the CFPB, with the majority finding the funding mechanism was constitutional. And to some, this may have been somewhat of an unexpected outcome, because at oral argument, the court seemed divided, with Justice Kavanaugh as the key vote. However, we have a 7-2 opinion written by Justice Thomas, who at the hearing expressed concern about finding the structure of the CFPB constitutional, and who argued that there might be few restrictions on the CFPB if Congress can allocate funding the way it did. And we also had some skepticism from Chief Justice Roberts, who, like Justice Thomas, found in favor of the CFPB ultimately. And Justice Thomas argued that, Chief Justice Roberts argued that the ability to fund the CFPB outside of the usual appropriations process was a very aggressive view of Congress's power and could lead to some issues with Congress intentionally giving away its power if Congress and the White House were controlled by the same party. The majority opinion written by Justice Thomas, it looked to the Constitution's text, it looked to history, and just the practice of appropriations following the ratification of the Constitution. And Justice Thomas wrote that the appropriations need only identify a source of public funds and authorize the expenditure of those funds for designated purposes to satisfy the appropriations clause. Here, there was no issue because Congress specified that the Federal Reserve was the source of the CFPB's funds, and Congress indicated how the CFPB could use that funding. And Justice Thomas concluded that the CFPB's funding scheme fell squarely within the meaning of an appropriation, and it reversed the Fifth Circuit's decision, which had stricken down the CFPB's funding mechanism as unconstitutional. So the first concurrence was written by Justice Kagan, who joined the opinion, but would take an even broader view of the appropriations clause. Justice Kagan interestingly said that the CFPB's funding scheme, in her opinion, would have been appropriate and would have passed muster in the late 18th century when the ratification, it would have been ratified then, and it would have been fine at any other point in the nation's history. And Justice Kagan recognized that there's a continuing tradition in which Congress can create a variety of ways to pay for government operations without violating the appropriations clause. And we had a short concurrence from Justice Jackson, who said simply that the CFPB's funding mechanism met the minimum requirements of the appropriations clause, and out of concerns for separations of power, she would analyze it no further. Taking the opposite approach, we have a dissent from Justice Alito, who said, in his words, the drafters of the Constitution would be shocked or even horrified by the CFPB's funding scheme. In his interpretation of history would lead to the opposite result. He found that the funding mechanism gave the CFPB the kind of financial independence that the appropriations clause was designed to prevent, and gives the CFPB an enviable amount of financial autonomy. And then he finally left us with some takeaways, which were that there could be real world consequences from the CFPB continuing with its funding mechanism, such as the CFPB being able to implement various sweeping consumer protection laws without the oversight from Congress or any checks and balances on its policies. So we'll take it with continue with our discussion of the administrative state.
Great, thanks, Jessica. Our next case is Ohio versus EPA, and continuing with the theme of the court curtailing administrative agencies' authority. This is an interesting combination between that approach to agency power, but also the Supreme Court's emergency docket, which you might have heard described as the shadow docket. This is kind of an interesting case because even though the court oftentimes issues stays, emergency stays, or decides not to stay a court opinion or regulation without oral argument, here they did have oral argument. So it's a relatively unique posture, and you get to see during the oral argument some of the justices talking about, well, why are we the first court to decide this? Why shouldn't you have the DC Circuit be deciding this? So there's some of those issues going back and forth. But specifically in this case, the court is deciding whether the EPA's plan to reduce ozone emissions that would apply in 23 states is enforceable or not. And in a 5-4 decision authored by Justice Gorsuch with a dissent authored by Justice Barrett, the court says, we think that this plan that the EPA has developed violates that it is arbitrary and capricious because the EPA doesn't adequately explain how it resolves some questions that were presented to it. And so the court issues a stay, preventing the EPA from enforcing this plan. So to back up just a little bit, the Clean Air Act, which is at issue here, gives the EPA the authority to set limits on emissions standards. So the EPA back in, I think it was 2017 or 2018, issued a rule that said, we're going to reduce the amount of ozone that we'll permit to be emitted. Now, the EPA sets that limit, but states typically are the ones that decide how to achieve that limit. And when deciding how to achieve those limits, states are required to keep in mind their neighbor states. And there's this rule called the Good Neighbor provision in the Clean Air Act that says you have to take into account how your pollution downwind might affect another state. So you can't just set up all your pollution on your border of a state and hope they deal with it. You have to take into account how your pollution is going to affect another state and curtail that pollution. So 23 states basically said, we don't think we're polluting enough to affect downwind states. And so we're not going to come up with a plan to mitigate our pollution. And so we're going to have this plan, but we're not going to do anything to mitigate our effect on downwind states. The EPA disagreed and said, no, you actually do have an effect on these downwind states, and you are going to cause pollution and problems for them. So your state plans that you have are not valid, and instead you have to comply with this federally created plan that the EPA came up with. And really the issue here is the EPA decided this plan based on an idea that all 23 of these states would be participating with that in that federal plan. The plan apparently seemed to be a reasonable plan based on all the data that they used, but it's based on this idea that every one of these 23 states is participating fully in that plan. And some commenters during the notice and comment period identified this issue and said, well, if some states aren't required to comply, how would that affect whether this is the most cost-effective way to reduce ozone emissions? And the EPA just kind of ignored those comments. It ignored those questions and issued this final regulation saying these 23 states have to comply with the federally implemented plan. It turns out that after that regulation went into effect, multiple states sought relief from the court. And at the time the decision was issued, only 11 or 12 states had not received a stay. So about half of the states that were subject to the EPA's plan didn't have to participate because of court orders. And those states accounted for about 70% of the total pollution that the EPA was trying to mitigate. And so the EPA hadn't explained how the loss of certain states or multiple states would affect whether the way in which it was approaching the pollution regulation was reasonable. And the court basically said, in order to determine whether we should issue a stay, we have to look at a balancing of the harms, but also whether the petitioner is likely to succeed on the merits. Justice Gorsuch said, the harms kind of weigh evenly because there's this big environmental problem, but there's also billions of dollars that'll have to be invested. And so really the only question is whether the petitioner is likely to succeed on the merits and prove that the EPA's regulation is arbitrary and capricious. One factor of whether a regulation is arbitrary and capricious is whether that it is adequately explained. And here, because the EPA ignored comments saying or asking about this issue and failed to describe how the plan would work if some states dropped out, the court said that fails to satisfactorily explain why it is acceptable to proceed. Justice Barrett, along with Justice Sotomayor, Kagan, and Jackson, dissented, arguing this case has a ton of vehicle problems. There are issues about whether these comments were actually raised. There are issues about timing of how the EPA could know that there were states that were going to not comply, and a whole host of other reasons why the court should not grant emergency relief right now, but wait until later on. So I think this is just another example of the court being eager to curtail agency power, and we may see some states or industries taking advantage of the court's willingness to do that.
Thanks, Ian. Finally, in a decision released on the last day of the term, and was kind of a sleeper case, but I think its importance will grow as the years go on, the court clarified how lower courts should be calculating the statute of limitations that applies when a plaintiff challenges an agency action. So specifically here, we've been talking a lot about the Administrative Procedures Act, but under that act, which is the typical mechanism for challenging agency rulemaking, that begins to run. You have 6 years to challenge an agency rulemaking under that. And so the issue was whether that timer starts to run when the agency issues its final action, so when it issues the rule, or when an entity or person is actually harmed or affected by that rule. So in this case, there was a North Dakota truck stop, corner post, that wanted to challenge a Federal Reserve rule that set a cap on debit card processing fees. So that rule went into effect in 2011. So the statute of limitations clock, if it started when the rule took effect, would have run out in 2018. But Corner Post did not start as a business and was not subject to those rules until 2018. So it argued, hey, we should have the full 6 years to be able to challenge this because we didn't even exist when this rule was passed. And the court agreed. In a split decision along ideological lines, Justice Barrett wrote that basically the text of the APA compels this result. That if we just look in a straightforward way at the language that the APA uses, claims will only accrue, and so start the clock on the statute of limitations when the plaintiff is injured by that final agency action, even if that action took place years or decades ago. So Justice Jackson, in her dissent, disagreed with this statutory interpretation, but she also drew out some of the practical consequences that I think could be coming from this decision. So she said, quote, now any established government regulation on any issue, say workplace safety, toxic waste, consumer protection, can now be attacked by any new regulated entity. And she noted that those concerns were especially compelling when considered in conjunction with the other cases that we've been discussing, in particular Chevron, to where now it just starts the clock anew for the court to decide we're going to issue our own viewpoint on the meaning of this agency action or regulation. So I think this decision now could put into play some rules and actions that have long been final, but now can be attacked anew if an entity either was already formed or newly forms in the years ahead. So this is one to watch out for.
All right, I'm going to talk about three, I guess I'll call them Trump-related cases now that came down this term. When I was in law school, my constitutional law professor said that we should all be indebted to the Jehovah's Witnesses for pushing the bounds, essentially, and establishing the limits of the First Amendment and religious freedom. I guess if that's the case, we should maybe be grateful for Donald Trump for pushing the kind of getting the course to determine the metes and bounds of presidential power and accountability. And these three cases address some of that. The first is Trump v. Anderson. So Trump v. Anderson dealt with what's called the insurrectionist disability in Section 3 of the 14th Amendment. And the question presented is whether a state may disqualify Trump from appearing on the ballot in Colorado, as the Colorado Supreme Court held, under Section 3 as a result of his activities in connection with the events of January 6th. The language of the 14th Amendment, Section 3, is this: no person shall be a senator or representative in Congress or elector or of president and vice president, or hold any office under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same. I'm just quoting the relevant language here. And then there's a sentence at the end that says, but Congress may, by a vote of 2/3 of each house, remove such disability. So the Colorado Supreme Court, relying on fact-finding from the district court, and that Trump had engaged in insurrection, disqualified from appearing on the ballot in Colorado for president. The holding in this case was that the insurrectionist disability of Section 3 is not self-enforcing or enforceable by the states against persons seeking federal office. Only Congress has the power to enforce Section 3 in the form of legislation directed to the specific insurrectionist. All the justices agreed in that result, but there was a dissent on the grounds that the majority had gone too far in saying that Congress had the exclusive power to exclude insurrectionists. So just briefly on this, the rationale for given by the majority is one, no, there wasn't any history of enforcement by the states of this clause against federal officers. And that's correct. I think there there was one instance, but it was a very isolated instance. The majority makes clear, though, that that only Congress has the right to exclude an insurrectionist under this clause. And for that, they really can identify no constitutional basis. They do point to Section 5, which says that Congress may enforce, may pass legislation enforcing any of the provisions of the 14th Amendment. But it's perfectly clear from jurisprudence that many of the provisions of the 14th Amendment, such as the term limit on presidency, are in fact self-enforcing and can be raised essentially by anybody to enforce them. So this is, I think, a broad policy argument that the court makes on both the enforceability of Section 3 and who has the right to do it. Everybody agreed, all the justices agreed, that allowing the states to determine which federal officers can appear on state ballots for federal office is a really bad idea. Again, purely pragmatic and policy driven, but all justices gave very significant policy reasons why that should not be the rule. We should not allow states to do that. It could allow one state, for example, or a small minority of states to determine presidential elections by excluding persons from the ballot. And it could also lead to essentially to chaos about which candidate and sort of retribution and various other tactics by states to try to keep people off the ballot. And so they all agreed on the pragmatic policy basis for this decision. The second case is Trump, and this is the case that I think really has gotten most notoriety. And the question was, does the president have absolute immunity for acts he takes in his official capacity, even those on what's called the outer perimeter of his presidential powers? And the majority, which was broke down right along ideological lines, held that although Trump doesn't have absolute immunity for all of his acts, that the president does have immunity for any action taken during the course of his core powers as president, and that he's entitled to presumptive immunity for any actions that are taken as a part of his official duties, but may not be his core powers. And then for his unofficial actions, he enjoys no immunity whatsoever. So what the court is very clear about is that if there is criminal activity taken as a part of a core function, such as the investigative power of the presidency, such as the president engaging in criminal activity as commander-in-chief, that he is absolutely immune from prosecution. That doesn't mean he's immune, obviously, from impeachment, but it does mean that he's absolutely immune from criminal prosecution. To get to this point, the court reviews the brief history of actions taken against presidents. And apart from President Grant's speeding ticket, which he got for running his horses too quickly down a Washington street, there really aren't any. The court notes that in civil actions, the president enjoys immunity, and analogizes that criminal action should be at least subject to the same level of immunity in civil actions. But it also notes that the subpoena power in the Nixon cases, Watergate cases, is enforceable against the president, and so the president can be investigated through the subpoena power. The court notes, really, though, that there is no constitutional basis for immunity. There's no constitutional language or other provisions that would suggest that the framers wanted the president to have absolute immunity for his core powers, or any other powers for that matter. The court then takes each of the actions that Trump was alleged to be engaged in and actually makes a determination, to some extent anyway, about whether or not he's immune from those actions. So action number one, discussions with the AG to investigate claims of election fraud. even if they were phony, complete immunity, because any discussions that the president has in connection with his investigative powers with the Attorney General is a core function. So no matter what its purpose, no matter what was discussed, the president has absolute immunity. Number two, getting Pence to use his position to delay or halt certification of the election. Here, because it was unclear to this court whether those discussions with the vice president were in his whether the vice president was acting in his executive capacity or his capacity as president of the Senate, the court found that needs to go back to be determined. But the court's very clear that if the president had discussions with the vice president about exercise of executive power in terms of delaying the election, the certification of the election, or other aspects of or certifying the election, that the president would be absolutely immune from criminal prosecution for that too. The court deals with the next item, which is the selection of fake electors, essentially, and setting up a slate of fake electors, another aspect of the indictment, and pressuring local officials to find votes. And the court says, somewhat astoundingly, that may be entitled to presumptive immunity, but sends it back to the lower courts to flesh that out, to figure out if it's within the bounds of his official actions. Inciting a riot, although the court says that's not clearly in his official capacity, the court suggests that inciting or that saying things, the presidents say things, they say things to execute their presidential powers, and that inciting a riot may actually be protected activity, but again, leave that to the lower courts to flesh out. The dissent obviously it takes issue with the significant enhancement of power of the presidency and departure from anything in the Constitution or any prior practice, and also decries the incentive that it believes that presidents are now given to commit criminal acts, including treason. The sort of famous SEAL Team 6 hypothetical that I think Justice Barrett made an oral argument comes up in the dissent now too. And what the dissent says is, if the president issues an order as commander-in-chief to SEAL Team 6 to assassinate one of his political rivals, that is almost certainly going to be an immune act, because we can't inquire into the motives of the president. You only look to whether he or she was acting in his official capacity. Justice Barrett did issue, although she joined the opinion in significant ways, she did think that the court went too far in implying a test about what constitutes core activity by the president. Commentators have obviously pointed out a couple of things. One is the potentially dangerous precedent of incentivizing presidents to engage in criminal activity. The other is that the test itself that the court laid out is very murky and may be difficult to apply. The last case, very quickly, is Fisher versus the United States, and that involved the Sarbanes-Oxley Act of 2002, which was one of the bases for indictment of President Trump, but also about a third of the rioters in January 6th were also charged with this. It's not their only charge, but it was one charge. And that was the Sarbanes-Oxley Act imposes criminal liability on anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other objects, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. The next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. So this was decided on statutory interpretation grounds, with the conservative majority finding that the subclause only applied to what appears to be the intent of the first clause to relate only to the obstruction or destruction of evidence, whereas the came down the other way and said that it's not limited to simply obstruction or destruction of evidence.
The court had two decisions that related to guns or the Second Amendment this term. I'll try and short circuit some of these. Taking the second case for Garland versus Cargill, that case, the court basically did a statutory analysis to determine whether the ATF exceeded its authority by defining bump stocks as machine guns or a component of a machine gun. And the court, in a very technical, narrow interpretation of the statute, held that because the bump stock didn't change the actual trigger mechanism to allow it to fire more than one bullet for each physical pull of the trigger, it wasn't actually a machine gun. So even though the effect of the bump stock allowed a rapid rate of fire, the mechanical components of the weapon didn't change such that it would become a machine gun. The bigger case, I think, this year in terms of guns and the Second Amendment is United States versus Rahimi. The courts across the United States have been struggling with the actual application of the Supreme Court's decision in Bruin from a couple years ago. In that case, the Supreme Court held that the only question when you're assessing the constitutionality of a firearm regulation is whether the firearm regulation is similar to or analogous to the historical and traditional regulation of firearms that existed at or around the time the Second Amendment was adopted. And the main question that courts have been grappling with is how similar is similar enough? And that's the direct question at issue here in Rahimi. The court was deciding whether or not a prohibition on people subject to domestic violence restraining orders, whether a prohibition on their possession of weapons violated the Second Amendment. And in an 8-1 decision authored by Justice Roberts, the Supreme Court said, no, that's not a violation of the Second Amendment because there are historical and traditional regulations of similar situations that would permit somebody to have their firearm taken away. And they point to two examples. One is a surety bond, where a wife could go to the court and say, I am prove that there's a legitimate fear of danger, and the court, back around the time the Second Amendment was adopted, would force the husband to put up a surety bond that if he became violent in some way, he would lose that money. The second analog historically was a prohibition on going armed. So if you were found to be a danger to the public, the court could basically take away your weapons. Justice Thomas is the sole dissent. He says those two analogs are not sufficiently similar, that putting up of money isn't the same as taking away possession of your weapon, and the going armed laws were more akin to kind of a public nuisance, public threat, as opposed to kind of a private dispute like we have here. I would recommend reading this decision if you're interested in how the court assesses the nature of history in its role as interpreting the Constitution. As Steve said at the beginning, although we kind of think about the court in terms of ideological blocks, it isn't a monolith. And this case is a really good example of that. There are 7 different opinions or 7 different writings as part of this. There's the majority, but then there's 6 concurrences and the dissent, all talking about the nature of history and its role in constitutional interpretation. So this is a good read if you're into that kind of thing.
Okay. So in our last little bit less than 10 minutes, we're just going to give some high-level takeaways from the other key cases and then a look ahead to this term. So similar to guns, in which they had to deal with the implications of their Bruin decision, the court was also forced to address the outcomes stemming from its 2022 Dobbs versus Whole Women's Health decision and its overturning of Roe v. Wade and Casey. In both FDA versus Alliance for Hippocratic Medicine and Moyle v. United States, the court essentially punted on the merits of the decision and decided both on procedural grounds. So the first decision, FDA versus Alliance for Hippocratic Medicine, dealt with the use of mifepristone as a medication abortion and whether the FDA's approval of that in 2000 and subsequent regulations expanding the use of violated were legal. This had gone up and down in Texas and the Fifth Circuit. The court ultimately, when it ruled on the issue, decided the plaintiffs challenging the law, doctors and medical organizations, did not have standing to challenge this law. So they essentially said, you weren't injured here, and or any injuries that you had were not caused by these FDA regulations, so you can't sue. We don't need to decide the merits, which means that challenges to the FDA's rules around mifepristone can come right back up to the court once they find a plaintiff who has standing to sue. And in Moyle versus United States, that dealt with states like Idaho, in this case, that passed broad abortion bans with narrow exceptions for emergency or basically just abortions where the life of the mother is at risk. The Biden administration and others said this is preempted by the federal emergency medical law that requires hospitals and emergency rooms to provide care to individuals in emergency situations. And the court said, okay, we'll hear this case. And then in June, they issued a one-sentence opinion saying, actually, never mind. They issued what's called a dig. So they dismissed it as improvidently granted. In these circumstances, the court doesn't explain why. But this was another case that might be interesting to read because there were 50 pages of concurrences and dissents where the judges are essentially arguing with one another on what we did here, why, and blaming potentially one another for why they couldn't come to a decision. There's also been recent reporting on this decision in particular around just kind of the back and forth among the justices that's made for interesting reading in the past couple weeks.
Let's skip to our discussion of the cases that are on the docket right now anyway, or cases that are likely to come to the docket for the 2024 term. The first one we wanted to just talk a little bit about was U.S. versus Scrimeti. So this is a question about whether Tennessee law, which prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to treat purported discomfort or distress from a discordance between the minor's sex and asserted identity, violates the Equal Protection Clause of the 14th Amendment. So this law, like the law in 22 other states, is targeted to medical treatment for what's called gender dysphoria, which is the medical treatment for transgender youth. And the theory here for the plaintiffs is that it violates the Equal Protection Clause because it targets transgender people and prevents them from getting the medical care that is available to other kids who may have, for example, delayed puberty or precocious puberty, but transgender people are not allowed to access the same level of medical care. And it's also, the plaintiffs argue that transgender people are a suspect class and therefore subject to a heightened standard. The Sixth Circuit disagreed with all that, and that'll be decided, I think, fairly early in the term this year.
The second case that we're going to be watching closely next year relates again to guns, and in particular it relates to whether a ghost gun kit is a firearm. So apparently, when you have a firearm license, you're required to undergo background checks, and so when you're manufacturing a firearm, you have to have these background checks, and when you produce a firearm, you have to put a serial number on that firearm so it can be tracked. In the last couple of years, there have been an increasing number of kits that have been sold to people that don't have any licenses. There's no serial numbers on them. And if you watch a YouTube video, you can basically put together a gun from these parts within 20 minutes or so. And so the question is, how close to completion does a kit have to be in order to constitute a firearm? And so that's the question that the court's going to be addressing in Garland versus Vanderstock.
Another case on the docket that deals with, again, the administrative state and administrative agency limits of power is 7-County Infrastructure Coalition versus Eagle County, Colorado. In this case, involves NEPA, the National Environmental Policy Act, and the question is whether the act requires reviewing agencies to only review matters that are essentially within their authority, or does it require them to review if as part of their exercise, they note that there are impacts to areas outside their authority, are they also considered to inquire into those as well? And there's a circuit split on this issue. The DC Circuit notably says they have to inquire beyond their authority. I think there are 5 circuits that come down the other way. So that'll be an issue, again, related to the administrative state. I guess we wanted to end up by pointing out that there are, we talk on all these seminars, we talk about the cases that have been accepted for cert now, but there are so many likely cases that haven't been accepted for cert yet, or based on events yet to happen, but that are quite likely to happen. And I would say in this case, the biggest one is the presidential election, obviously. There may be issues related to the legitimacy of, last minute statutory changes on voter ID and registration, on legitimacy of counts and certification. On will the court be asked to address the legitimacy if there's an attempt to have the House decide the presidency in a situation in which there's some problem with certification of votes from a variety of states such that neither candidate gets a majority. I think those are all possibilities. The court has obviously weighed in on elections before with U.S. v. Gore or Trump v. The Gore case. I can't remember who the other party was in that one. The other issue that's likely to percolate up at this point too is the legitimacy of special counsel. So Justice Thomas has questioned the legitimacy of special counsel in concurrences. This was obviously picked up in a decision that Judge Cannon issued on the documents case on which Trump has been indicted in Florida. I think that's likely to reach the court this year, depending on who gets elected, because there are a lot of undecided Trump-related issues that may never come to the fore if Trump gets elected. So with that, Bush v. Gore, thank you, Chatter. With that, we'll end our presentation today, and thank you very much for attending both in person and on the webinar. Again, if you have any questions, feel free to launch them and we'll be sure to get back to you. Thanks again.